Companies Act, Section 403, Fee for filing, submission, registration, and recording of documents. Section 403 outlines the financial obligations of companies and their officers when filing statutory documents or submitting information to the Registrar of Companies, ROC. It ensures timely compliance with legal requirements by prescribing ordinary filing fees as well as additional fees and penalties for delays or repeated defaults. This provision emphasizes both regulatory discipline and accountability in corporate governance. 1. Requirement to file documents within prescribed time and payment of prescribed fee. The law mandates that any document, information, return, or record that is required to be submitted, filed, registered, or recorded under any provision of the Companies Act must be completed within the time limit specified in that particular section. At the time of such filing or submission, companies must pay the normal statutory filing fee as prescribed by rules under the Act. This applies to a wide range of compliance documents such as annual returns, financial statements, changes in directors, charges, registered office details, and various statutory notices. A. Delayed filing of annual return, Section 92, and financial statements, Section 137. If a company fails to file its annual return under Section 92 or its financial statements under Section 137 within the prescribed time, it may still submit the documents after the deadline, provided that an additional fee is paid. This extra fee shall not be less than 100 rupee per day of delay, and may vary based on the class or category of company. This ensures that critical annual disclosures are taken seriously, since they provide transparency to shareholders, creditors, regulatory authorities, and the public. B. Delayed filing in cases other than Sections 92 and 137. For all other forms and documents required by the Act, if there is delay beyond the statutory period, filing may still be allowed, however. The company must pay additional fees prescribed for delayed submission. The additional fee may differ depending on the type and size of company. This grants some flexibility while still encouraging punctual compliance. C. Higher additional fee for repeated defaulters. Where a company defaults on filing requirements multiple times, i.e., 2 or more occasions, then filing will still be allowed after the deadline, but the applicable additional fee will be higher than in cases of a first-time default. This is without prejudice to any other liability or legal consequences. This acts as a deterrent against habitual non-compliance and encourages companies to maintain consistent filing discipline. 2. Liability for penalty in addition to filing fees. If a company fails to complete filing or submission within the prescribed time, both the company and the officers in default shall be liable to incur penalty or punishment as provided elsewhere in the Act. This penalty is in addition to normal filing fees and additional fees for delay. Therefore, payment of the delayed fee does not absolve the company or its officers from legal proceedings or penalties for non-compliance. Objective and importance of Section 403. Promote timely regulatory compliance, prevent accumulation of undisclosed information, ensure public transparency about corporate affairs. Enforce accountability through financial consequences, discourage repeated or willful delays by imposing stricter penalties for recurring defaults. In a broader sense, Section 403 plays a crucial role in maintaining order, accuracy, and reliability in the statutory records of companies in India. For more details, contact us.